This week brought some genuinely significant developments in Australian immigration law. And if you are on a temporary visa, working towards citizenship, or have children born in Australia, at least one of these updates applies directly to your situation. Before we dive into it, subscribe to get more updates. Let us get straight into it. The new Migration Arrival Control Determination Act 2026 passed last week and has now been formally enacted. In practical terms, what this means right now is a 6-month temporary travel ban preventing Iranian nationals from entering Australia on temporary visas. This week has delivered some truly important developments in Australian immigration law. If you're currently on a temporary visa, working towards citizenship, or have children born in Australia, there's a strong chance that at least one of these updates directly affects you. Let's go straight to the key points. The newly introduced Migration Arrival Control Determination Act 2026 was passed last week and has now officially come into force. In practical terms, it introduces a 6-month temporary travel restriction, preventing Iranian nationals from entering Australia on temporary visas. Home Affairs Minister Tony Burke triggered the law, citing concerns that visitors from Iran may be unable to return home given the current situation in their country. Exemptions have been built into the framework for spouses and dependent children of Australian citizens, and for Iranian nationals who were already in transit to Australia when the determination came into force. But here is what you need to understand clearly, because the official framing of this being about people who cannot go home does not tell the complete story. The real purpose of this legislation is to prevent people from arriving on temporary visas and then immediately lodging protection visa applications on the basis that they fear returning to their home country. That is the specific mechanism the government is attempting to close. There is provision for the minister to exercise discretion and issue individual travel permits on a case-by-case basis where circumstances warrant it. How quickly those applications would actually be assessed and what the practical criteria for approval will look like in practice remains entirely unclear at this stage. A Home Affairs Minister activated the law, pointing to concerns that some visitors from Iran may not be able to return home due to the current conditions in their country. The framework does include exemptions, particularly for spouses and dependent children of Australian citizens, as well as Iranian nationals who were already en route to Australia when the measure took effect. However, it's important to look beyond the official explanation. While the policy is framed around the risk of individuals being unable to return home, that is not the full picture. A key objective of this legislation is to limit situations where individuals arrive on temporary visas and then quickly apply for protection visas, claiming they cannot safely go back to their home country. That is the specific pathway the government is seeking to restrict. At the same time, the legislation allows the minister to apply discretion by granting individual travel exemptions on a case-by-case basis where justified. That said, it remains unclear how quickly such requests will be processed or what criteria will ultimately be used in practice to approve them. The determination is set to remain in effect for 6 months. If your temporary visa expires during this period and you need to stay, you'll be required to submit a new application. There will be no automatic extensions of existing visas. It's also important to note that while the current restriction does not apply to other temporary visa categories, the legislation gives the government the authority to expand it to additional groups if deemed necessary in the future. For individuals holding passports other than Iranian passports, these measures do not apply. Now, turning to 2 key updates regarding Australia's citizenship rules. Most applicants are required to meet the general residency criteria outlined under Section 21 of the Australian Citizenship Act. This typically means spending no more than 12 months outside Australia in the 4 years before applying, and no more than 90 days outside the country in the 12 months immediately prior to the application. The special residency pathway is designed for individuals who are unable to meet these standard requirements due to the nature of their work, particularly where extended time outside Australia is unavoidable. This week, 2 significant new categories were officially added to the special residency framework. The first category is academics. Individuals holding a PhD and employed by an Australian university who are engaged in research that benefits Australia can now have their time spent overseas considered as part of their citizenship application, provided those absences are directly linked to their research activities. This includes attending or presenting at international conferences, participating in collaborative research projects abroad, and sharing research findings in global academic settings. Previously, this type of consideration was limited to scientists. The update now formally acknowledges that academics also require consistent international engagement as part of their work. The second category applies to ministers of religion. Senior religious leaders are now also eligible under the special residency provisions. The amendment recognizes that such roles often involve frequent international travel as part of leadership responsibilities within religious organizations. It's important to note that this exemption is specifically tied to duties performed in an official leadership capacity. Travel undertaken for personal religious reasons does not qualify under this provision. The key point here is that the amendment is intended to recognize professional leadership responsibilities, not religious activity in a broad or general sense. Now, turning to a question that gained a lot of attention after last week's discussion, how children born in Australia can obtain citizenship and how the rules actually work in practice. In Australia, children born in the country who remain ordinarily resident for their first 10 years of life may be eligible to apply for what is known as evidence of citizenship. This status is not granted automatically. You must submit a formal application along with supporting documentation. The concept of ordinarily resident is especially important to understand. It does not mean the child must be physically present in Australia every single day over those 10 years. Instead, the focus is on the overall living arrangement, particularly whether the child's parents held valid visas and were themselves ordinarily residing in Australia during that period. Under this framework, there have been cases where children spent significant time outside Australia, sometimes even several years, and were still granted citizenship. What matters is that their broader circumstances met the ordinarily resident criteria. For example, there has been a case where a child qualified for citizenship despite spending around 5.5 years outside Australia during that 10-year period because the overall residency criteria were still satisfied. The framework is more flexible than many people assume. The ordinarily resident test is applied to the family unit as a whole, rather than focusing solely on the child. This is a critical point, especially given the reality that many temporary residents live in Australia for extended periods. For instance, there is no strict limit on how many times someone can hold a subclass 482 visa, making it quite common for individuals to spend 10, 15, or even 20 years building their lives in the country. Australia does not treat temporary residents as second-class members of society, nor does it discourage them from having children while living there on temporary visas. Children born in Australia who meet the citizenship criteria have the right to remain, continue their education, and build their future in the country, regardless of any later changes to their parents' visa status. This principle is fundamental, embedded in legislation, and should not be underestimated. Bringing everything together, the most immediate issue this week is the 6-month travel restriction affecting Iranian nationals. If you or someone you know is impacted, it is important not to rely on ministerial discretion being applied quickly or consistently. If your plans involve traveling to Australia in the near future, it is strongly advisable to seek professional guidance tailored to your specific circumstances, rather than waiting to see how the policy develops. If you are an academic or a senior religious leader who has found it difficult to meet the standard citizenship residency requirements due to work-related travel overseas, these new changes to the special residency provisions could create an opportunity that was not previously available. It's worth reviewing your situation carefully to determine whether you may now qualify to apply. Similarly, if you have children born in Australia who have lived there for a significant period, it's important to understand how the citizenship by birth and residency rules apply in your specific case. The process is not automatic, and the evidence requirements are substantial, but for many families, it is a realistic and worthwhile pathway. If any of these updates relate to your circumstances and you're uncertain about what to do next, it's strongly recommended to seek advice from a registered migration agent before taking action. When it comes to immigration matters, making decisions based on assumptions can be far more costly than getting accurate, professional guidance from the start.